From The Australian, here's what's on the front. I'm Claire Harvey. It's Tuesday, November 12. Ancient Indigenous rock art could be painted over to make it more visible. That's the startling proposal from some First Nations leaders at a Victorian rock climbing site that's become a battleground over tourism versus cultural heritage. Australia's plans for a $1 billion giant supercomputer are in doubt as Queensland's new government announces it's reviewing whether it still wants to go ahead. Those stories are live at theaustralian.com.au right now. The most important court cases are full of juicy details, and some of it shouldn't be in the public domain. That's the take from Federal Court Chief Justice Debra Mortimer. And it's put her at odds with her own court's superstar judge, Michael Lee. Today, how much are we allowed to know? In a newsroom, there's an exciting part of the day when the court reporters come back from the cathedrals of justice to tell us what's been going on. At The Australian, our legal affairs correspondent is Ellie Dudley. Ellie, there's been an amazing case going through the federal court of a former Channel 7 Spotlight employee taking legal action against the network. Tell me all about it.
Yeah, so let me tell you, Claire, this has been an incredible case. It's all about Amelia Saw, who's a former employee at 7 Spotlight. She is suing the network over allegations.
Oh, sorry. We can't bring you the juice on this case. And Ellie, the big corporate scandal that's going on right now is Super Retail, this company that has run into trouble with several employees. Tell me what's going on there in the federal court.
So that's an incredible case. You've got Super Retail, which is just this mammoth retail behemoth, and these allegations of sexual harassment that have come out from...
Oops, can't share that either. So, Ellie, those are two cases that we would absolutely love to be talking about on the front today, but we can't. Why not?
So in the federal court, Claire, there is this debate that appears to be going on about open justice and suppression orders, an order that comes from the court to suppress either key details or the names of witnesses or the names of parties or documents to prevent it from being published by the media and being spread more widely.
If there's anything more interesting than a gritty court case, it's senior judges engaging in a very public difference of opinion. And that's what's happening in the Federal Court of Australia, where the court's superstar judge, Michael Lee, and its boss, Chief Justice Debra Mortimer, are at odds about how much you get to hear about what's going on. There's a general principle in court reporting that you could wander into pretty much any court in the country, sit down at the back as a reporter and start taking notes about what's happening, given that this is taking place on taxpayer-funded premises with judges and sometimes counsel who are being funded by the taxpayer. That's not always the case anymore, is it?
This is what the judges in the federal court appear to be grappling with at the moment. The Chief Justice of the federal court saying that open justice is not open slather. Open justice does not mean that every juicy detail should be available to the media and available to the public more broadly.
Ellie's breaking a story today about a speech given by Debra Mortimer, the Chief Justice, in which she said, basically, back off. We've used a voice actor to bring you Justice Mortimer's words.
Media and community aspirations to obtain all the juicy details have never operated as some kind of open slather on disclosure of information in court proceedings. Most of us who speak or write about the concept of open justice are either official participants in the justice system or observers of it. Thus, it is not our story of intimate physical violations or our precarious mental health or our gambling addiction, which has led to our bankruptcy, nor our contractual arrangements designed to save our business, which are at stake. We have no skin in the game.
Mortimer said judges and journalists should remember the law operates on the lives of human beings, and that every time there's a juicy morsel of information, There's also a human being who might be personally affected. So let's go back to the genesis of this story. Why is Chief Justice Debra Mortimer talking about this?
We've been talking about open justice for decades and what open justice means. Does it mean that someone is just able to walk into a courtroom, sit up the back and watch what's happening? Or does it mean that, especially now in a digital age, that a reporter or a member of the public should be able to access every detail that's included in a case? The reason that it's so interesting to me as a legal affairs reporter is that it appears that the judges of the federal court have differing views on what open justice is. We've got Justice Michael Lee, who our listeners would be familiar with as the judge who presided over the Bruce Lerman defamation case against Network 10.
Having escaped the lion's den, Mr. Lerman made the mistake of coming back for his hat.
He also presided over Heston Russell's defamation case against the ABC.
There is not some sliding scale, which means the greater the public interest in the matter, the greater the margin for error in what is published.
Justice Michael Lee said he has no doubt investigative journalist Mark Willesee believed the publication of the stories was in the public interest, but that the belief was not reasonable in the circumstances. He's awarded Mr. Russell $390,000 in damages, having previously ruled the stories conveyed defamatory imputations.
He thinks that if there's an application for a suppression order, the media should come in and fight it and fight for the details to be made public.
In August, Justice Lee said at a Women in Media conference that he was tired of corporations and other litigants who come to court asking for swingeing confidentiality or suppression orders to prevent the publication of evidence. Justice Lee said one way the media could do better is ensuring that courts and judges are held to account when it comes to suppression orders. He urged media organisations to engage barristers, and he acknowledged that can be expensive. He said don't waste money on top silks, just use comparatively cheap junior barristers to argue against suppressions. Lee said part of the problem was that often both parties to a case agreed to a suppression, the lawyers for the plaintiff and the defendant. That means it's up to media organisations to fight. Listeners to The Front would know that during the matter of Bruce Lerman versus Network 10 and Lisa Wilkinson, there was a YouTube live stream every single day. The vast majority of those proceedings were live streamed. There were a couple of moments when the court was closed and all the reporters had to gallop down there to report on what was going on. Tell me about that instance when the court was closed, why it was.
Yeah, so in that instance, it was closed because one of the witnesses, Fiona Brown, had incredibly fragile mental health. As I mentioned, Justice Lee was the one presiding over that case, and he was very keen for every element of that case to be public. He uploaded documents and evidence all onto an online file that was accessible to journalists, but also accessible to the general public as well. And he wanted the case live streamed. He wanted everybody to be able to see how this matter was playing out because it was a matter that was so firmly in the public interest. He closed the court, I think, quite reluctantly when Fiona Brown was giving evidence in order to protect her mental health in that instance.
It's really understandable that judges would want to protect the mental health of fragile witnesses and would want to prevent undue stress to people who are appearing before the court. But it's worth remembering that pretty much every matter that reaches court is the result of some kind of conflict, right?
Absolutely.
Someone's always going to be upset.
Yeah, absolutely. And I think the thing to remember for judges is that embarrassment isn't a reason for something to be suppressed.
Coming up, do we really want to see litigants tearing each other apart on live TV? Speaking of juicy cases, there's a ripper going down in the Magistrates Court in Melbourne, and we've got it exclusively. It's all about a Victoria police advisor who's faced court accused of impersonating a police officer, perjury and perverting the course of justice. Check it out at theaustralian.com.au. In the United States, there's much more of a presumption towards openness than in Australian courts, and we know how that can go.
This gets you your 15 minutes of fame.
Objection, Your Honor. Argumentative.
I could see the same thing by taking Everett as a client for you.
A little argumentative, don't you think?
Oh, hardly.
In Australia, the closest we get is the federal court's YouTube live stream. The other thing that the judges can't really control is that those 20,000 people who are watching a live stream can then go on Twitter or Instagram or Facebook and spout their opinions. Say, I think so-and-so was lying, I watched such and such as evidence, and I think it's all a bunch of nonsense.
What's the argument between somebody watching it on a YouTube live stream or somebody reading it in the media? You know, we're always going to be there for the big cases, reporting on them and putting up our articles as quickly or, you know, in real time if we can. What's the difference between somebody reading one of those and spouting their opinion versus watching it on a live stream?
I must say, having covered a lot of court cases just like you, they are fabulously entertaining.
Of course they are. Yeah, especially those that are live streamed. You know, we've got Moira Deeming v. John Pizzuto, which has been live streamed. The Heston Russell case was live streamed. Obviously Lerman as well. They're incredibly entertaining. It's why my job is so fun.
Okay, this is reminding me a little of the distinction between the public interest and what the public are interested in.
Which is a funny line to walk at all times, right? As a journalist, you think about that all the time. Is this story in the public interest, or is this just something that people are going to love because it's got such sordid and juicy details? And I think that's something that Debra Mortimer is walking quite close to in this. You know, she says that community curiosity has never prevailed in any absolute sense when it comes to open justice, but instead it needs to be balanced with what open justice actually means.
Often there are seats set aside in courts for the media. It is clear that the press are allowed into courts. That is a basic rule. But I do feel that a lot of the time we're treated with contempt. I've found myself sitting on the floor a lot of times in court hearings. A good example is the Supreme Court trial of Christopher Michael Dawson, which we covered in such intensity. Journalists gathered 3 hours before the court opened to be able to get in and then still had to fight for seats. Many people didn't actually make it into that courtroom. What do you think?
It's a balancing act, isn't it? Are we part of the system? No. But do we play a really fundamental role in justice being served? I think yes. I think that if we think that courts should be heard in public, then if we're the facilitator between something occurring in a court and the public finding out about it, then I think that the media plays an incredibly important role in those instances. How that relates to suppression orders and the individual circumstances of an individual case is probably another question. And the point that Debra Mortimer makes is that each case needs to be handled differently depending on the circumstances that are before the judge.
Ellie Dudley is the Australian's legal affairs correspondent. Thanks for joining us on The Front. The Prime Minister and the Governor-General named a new Victoria Cross recipient yesterday, Private Richard Norden, honoured for his remarkable gallantry during the Vietnam War. You can read all about his courage under fire right now at theaustralian.com.au.